Now turning to Mr. Hebert.
Chair, Mr. Langtry, I appreciate you being here to give us your insights into the strengths and weaknesses of our Canadian Human Rights Commission system. Given the shortness of today's witness time, I would ask that you be willing to provide answers in writing to questions that we submit to you after this proceeding. Would you be okay with that? Great. And I also have more questions than I have time for, so I really urge you to keep your answers as brief as possible. Thank you. I note that in recent years, the Commission and the Tribunal have conducted secret hearings to withhold evidence from defendants, to conceal the names of accusers, and to even exclude a defendant from portions of his own hearing, among other things. I, too, am a lawyer, and as I'm sure you would probably know, such practices do not occur in regular courts. If they did, they would bring the administration of justice into disrepute. So my first question is, who approves these kinds of legal tactics? And the second question is, does either the Commission or the Tribunal have any sort of a manual of legal procedure that must be used during these hearings, or do they actually just make it up as they go along?
Thank you for the question. I appreciate the opportunity to, albeit briefly, as you suggest, to describe our processes. As you well know, of course, we are an administrative tribunal, and as such are subject to the rules of procedural fairness, and all of our decisions are subject to review on judicial review.
Document of legal procedure?
We have operating procedures that we follow, certainly, which is more in terms of the time periods within which complaints and responses must be filed and so on.
Anything like that would be appreciated.
Sure.
And my other question was, who approves the legal tactics that you use?
Well, there really are the legal tactics, if you will, are conducted in the same way before the tribunal in virtually every case. When we would make any kind of special request, we have to establish before the tribunal. As you know, there's no hearings at the Commission.
At the Commission or at the Tribunal will make a decision as to whether or not to have, a so-called secret hearing on some of these issues. It's not directed by yourself or anybody in authority.
Well, if on one occasion when an application was made before the Canadian Human Rights Tribunal to permit one of the witnesses to give evidence, had to state the case, our lawyer had to state the case as to why a great exception would be made to the usual, and the foundation of that was based on concerns of potential security or safety, but it's up to the tribunal then whether or not to accede to a request, and that was made in one instance that I'm aware of, and I'm only aware of one instance.
Okay. Moving on. It's not escaped the notice of parliamentarians that some Commission investigators have broken the law. And here I'm referring to the posting of large amounts of hate speech material on the Internet by your investigators, the theft of Internet service during a recent investigation. I also note that the Commission has hired some questionable people. One was a former police officer who was kicked off the force because of corruption. An internal governance audit in 2003 gave the CHRC a failing grade for ethics, and it was found not to have had an ethics code or manual in 2003. Since that time, has the CHRC adopted an ethics code? And if so, would it apply to the screening of potential hires? Would it have prevented the hiring of a corrupt individual?
Just if I might be permitted to respond to the preamble before the question. The fact of the matter is that some of the information that has been in the media and some of the descriptions of what we have done, we feel are untrue. And as part of our special report, we have detailed what our process is. For example, the allegation of the theft of the Internet That was untrue, and the RCMP investigation and the Privacy Commissioner investigation both came to the determination that there was either no evidence or insufficient evidence to proceed further. In terms of our code of conduct and ethics and the like, we are subject to, of course, all of the Government of Canada codes of ethics, codes of conduct, all of the legislation pertaining to all of our employees. We do not post hate messages, and I can tell you that the Commission would not condone any of our employees doing so.
Thank you. Now, your website tells us that just 2% of complaints, each year are Section 3 hate speech complaints. This indicates that so-called hate speech complaints are a relatively minor portion of what the Commission does. What's even more interesting is that it's the same individuals responsible for virtually every Section 13 complaint that has been sent forward to the tribunal in the last 8 years. I'm sure you know Richard Warman. Of the 14 complaints that have resulted in a decision from the tribunal since 2001, 12 out of 14 since 2001 have been brought by Richard Warman. So essentially, without Mr. Warman, it would appear that the law would not really be used that much at all. Is it true that Richard Warman has received over $50,000 in awards through the tribunal process over the years? And is it also true that the Commission has given him thousands of dollars more in expenses as a so-called witness to his own complaints?
I can honestly say I'm not aware of what awards Richard Warman, as you know, we're not the tribunal. I do not know. I do not have a number. We can certainly look into that. I certainly have no knowledge of any amounts that that the Commission has paid to Richard Warman. I'm not aware of that, and I certainly can seek that information and provide it to you.
Very much appreciate that. Thank you very much. It certainly would be suspicious to have an individual who was a former employee being paid to be a witness at his own complaints and then receiving such awards. In your recent memo to Parliament last week, you claimed, as you did earlier today, that there's no hierarchy of rights, only a matrix of rights in which all rights are equally important. But our Charter of Rights and our Bill of Rights both list freedom of expression as a fundamental right, one that takes precedence over other values in society. Why does the CHRC not believe that freedom of expression is a fundamental right? Follow-up question. In the report, you also indicate that freedom from hate is a priority that's given equality to freedom of speech. This concept of freedom of hate is in the title of the document. Could you tell me where in the Charter or where in legal context in Canadian law does this freedom from hate exist, or where was it first described or invented? Two questions.
I can't give you the origin of where that existed, but certainly, obviously, from our perspective, it came from Parliament in terms of our mandate to deal with hate on the Internet. Section 13 is a creature of statute, as you know, and came from the mandate of Parliament. In terms of the balancing and the limit, that was, as you know, as well, considered head-on in light of the Charter by Taylor, by the Supreme Court of Canada in Taylor in 1990. And the decision at that time of the Supreme Court, they released both the Taylor and Keegstra decisions on the same day, and they upheld the constitutionality of both Section 13 of the Canadian Human Rights Act as well as Sections 318, 319 of the Criminal Code of Canada. So it is based on that, and then again, as I had referenced, the 2001 amendment to our Act, again by Parliament, as part of the Anti-Terrorism Act, to expressly state that it did cover hate on the Internet, which the tribunal had already determined was the case. So we take the mandate from Parliament, and we take the balancing, if you will, and the restriction on freedom of expression from the court cases. These are not decisions that are taken by the Commission. We are subject to Parliament and the mandate that you as parliamentarians give to us or take away.
That completes the questions that members can ask. I